Hi, I'm Tom O'Toole with Sound Jury Consulting, and welcome to this edition of Soundbite CLEs. Today my goal is to give some simple but effective advice to witnesses who are about to give testimony in a deposition. I am a jury consultant that is based out of Seattle, Washington, but I work across the country in all different types of cases. I have a PhD in legal communication and psychology from the University of Kansas, the collegiate home of Will Chamberlain. I study the American jury, and as part of that, I study and conduct research on how juries, judges, and other triers of fact perceive and react to witnesses. I work with all types of witnesses across the country to help them get ready for their testimony. I've worked with brain surgeons, truck drivers, actors, engineers, corporate leaders, and everyone in between. Consequently, I understand the wide spectrum of problems and stressors that witnesses face when they have to give a deposition. I think it's important to start by discussing how your job in a deposition might be a little different than what you had thought. There are some important elements to a deposition that may not seem intuitive. For starters, a deposition is not the time to, quote, get your story out. Your job in the deposition is to answer only the questions that are asked and not provide a lot of information outside the scope of those questions. I know this can be frustrating because there are probably lots of things that you want to say, and the questions you're asked in your deposition may not give you the opportunity to say them. But the deposition is not the time for that. That time will come at trial. Second, it is important to understand that you are the one in control in your deposition. You might feel as if you're being thrown into a room with some sort of shark who gets to call all the shots, but that's not the case. You are the one in control. You get to choose how to answer the questions. You can ask to see a document if it'll help you answer a question better. You can tell the attorney you don't understand the question and ask him or her for clarification. You can ask to have the question repeated. You can disagree with characterizations and assumptions built into those questions. You get to take a break whenever you want and how often you want, as long as the attorney is not waiting on an answer from you to a question he or she has asked. These are just some of the examples. You are the one in control, and you should approach it as such, as long as you do so with a polite and respectful tone. Finally, your job is to tell the simple truth. It is what it is, and it's important to own the truth. The more you try to run from it, the more attention it will bring to the issue. And don't try to be strategic. You should not try to out-lawyer the lawyer. You will always lose in that situation. You cannot win your deposition, but you can lose in your deposition. And that's important to understand. Even if it feels good to you, it will look very bad to a judge or a jury down the road, and it will come back to haunt you in important ways if you try to get too clever and you try to be strategic in your deposition. As I mentioned earlier, I work with a lot of witnesses across the country to help them prepare for their depositions. I start every session with witnesses with 3 ground rules. I believe these 3 ground rules cover the vast majority of issues that may arise in your deposition. Those ground rules are, first, take the deposition one question at a time. Listen carefully to the question and answer only that question. Don't think strategically and try to answer the question you think is going to follow the question that has actually been asked. It will only lead to more questions that might not have otherwise been asked. Second, think about whether or not you agree with the assumptions and descriptions built into the question. Voice disagreement when that happens. For example, if I were to ask, "Did you buy that ugly shirt at Macy's?" You don't have to agree with my characterization of the shirt. You can say, "Well, I would disagree that it's an ugly shirt, but yes, I bought it at Macy's." In this respect, a deposition is primarily an exercise in listening. You may think as the witness your job is to talk. And yes, you have to provide answers, but the more important task is listening and listening closely to make sure you understand what is being asked and you agree with all of the things that are built in to that question. The third ground rule is every answer should come from one of three categories: what you personally know and remember, what the records show, or what your common practice was. Anything else is speculation and should be avoided at all times. Speculation and educated guesses are perfectly fine for casual conversation in everyday life, but they should not happen in your deposition. If you don't know the answer, the only answer you should give is "I don't know," or "you'd have to talk to so-and-so." Don't guess, don't speculate, no matter how helpful you're trying to be or no matter how reasonable the guess seems. The only appropriate answer is "I don't know." A deposition is not like a test where "I don't know" is a wrong answer. If it's the honest answer, it's the best answer. Don't speculate or make educated guesses. That will only get you in trouble. These three rules will take you very far in your deposition. Despite the fact that it may feel overwhelming or intimidating, which is a very natural and understandable feeling, a deposition is a very simple process. You are asked a question and you answer that question. That's it. I hope this information helps you in your upcoming deposition. I encourage you to watch this video one more time the night before or the morning of your deposition as a simple reminder and a reassurance that you will be just fine if you follow these simple rules. For more trial preparation tips, check out the publication section of the Sound Jury Consulting website at www.soundjuryconsulting.com. My name is Tom O'Toole, and thank you for tuning in.